Today, we're going to be talking about the overturning of Chevron and its effect on intellectual property law. I have here with me Jack Passero, who's been with us over the summer and has done a lot of research in this subject. So, Jack, welcome.
Thank you.
Today, why don't you tell me or tell the audience about what is the Chevron deference?
Yeah. So Chevron deference, for those who are not familiar with administrative law, is a case that was decided in 1984. It was Chevron versus the NRDC, or the Natural Resource Defense Council. It kind of focused on statutory interpretation. So when you think of specifically in that case, it was the EPA, so the Environmental Protection Agency. These agencies are full of a lot of employees, or full of a lot of people, and there are a lot of these agencies, and they have to make decisions. They interpret rules, but they technically have no statutory authority to. And so statutory interpretation and regulation is not in their job description as an agency. That should technically and constitutionally be the role of Congress. And so in Chevron, it was decided that these agencies would be given some authority to interpret statutes, and that was a two-pronged test. So the two-pronged test there was, first, whether Congress has spoken directly to the issue at question, and then second, whether the agency's answer is based on a permissible construction of the statute. So what that essentially meant specifically in Chevron was the EPA's interpretation of the word source for a source of air pollution. And the NRDC was kind of going against the EPA there, and courts decided, or the Supreme Court decided rather, that the EPA's statutory interpretation of a source of air pollution was a permissible interpretation of the statute. And so courts have been relying on Chevron for a while to give agencies deference to statutory interpretation and give them responsibility to sort of ease up on litigation that might result from such interpretation. At least that was the case under Chevron.
Wow, it's literally the whole case turned on one word.
Yeah.
So Congress better be pretty careful on the words they use. And I believe that just recently that there was another Supreme Court decision, and they considered the Chevron deference. And what happened? What did the Supreme Court decide?
Yeah, so that was back in June of this year, 2024. Chevron was overruled in the case of Loper Bright Enterprises versus Raimondo. You'll see it around as just Loper Bright. And now statutory ambiguity has been resulted in what's called Skidmore deference. It's kind of a step back. It was what was around for 40 years before Chevron. So I guess that's 1944. So going a little bit back there. But it's a kind of a large change to get into piece by piece. But essentially what it means is statutory authority and ambiguity is decided by judicial measures now, more or less. So what that would mean is, instead, say the case of Chevron arguing what source meant, it wouldn't go to the EPA's interpretation. It would instead go to what the court interprets that to mean. So they're not completely ditching the agency interpretation. However, agencies are still given some sort of like expertise authority. So kind of they'll ask what the agency thinks it means, but what the agency says is not binding anymore. Even if it is a reasonable or permissible interpretation, that deference has now been overturned and back to Skidmore deference.
So let's discuss intellectual property. How do you think that this decision might impact how the USPTO operates and how it goes through its process of prosecuting applications?
Yeah, so luckily for those involved in intellectual property law, the USPTO will not receive much backlash or a reduction in authority. It's assumed. They don't do a bunch of statutory interpretation. And what's going to happen now with Chevron being overturned is statutory interpretation is now going to result in increased litigation. It's going to cause a lot of time in courts where other matters may be able to be discussed. Rather than quickly getting through these matters with Chevron deference, as some might see, it might take a little bit longer. Luckily for the USPTO, USPTO already has little to no authority for statutory interpretation. Rather, a lot of their statutory interpretation involves procedural matters. I know, as an example, for one of our previous podcasts, linked in the description is an attachment to a presentation on the Section 101 guidelines that the USPTO has provided with regards to subject matter eligibility. In that presentation, there's reference to a case that kind of shows the Federal Circuit interpreting the rule of the USPTO as influential but not binding. That's a CX Loyalty versus Merits Holdings. Subject matter eligibility is a matter for courts to decide, and the USPTO guidance was not binding on that matter. So USPTO has already kind of gotten their authority limited in the sense that there will not be really any issues or much change with that regard from Chevron being overturned.
I remember a few years ago, there was a case revolving the authority of the USPTO and relating to its appointment of administrative law judges. I'd be curious to know how that decision might have been impacted. But let's get to, if there's not a lot of impact on intellectual property, what other agency or agencies do you think that this overturning of the Chevron deference would have a more significant impact?
Yeah, so specifically with regards to intellectual property, one of the largest areas that might see some change is going to be within the ITC. So the ITC gets its statutory authority from the 19th volume of the U.S. Code, Section 1337 specifically, which authorizes the ITC to pursue the investigation of any alleged infringement, mainly on importations that infringe on patents. However, it is an infringement on any intellectual property as a result of the importation of goods. So the ITC has seen a history of these challenges because that may result from the importation of goods as a whole or goods in part that can be manufactured together to result in an infringement as a whole. And there is no exact statutory authority regarding the ITC's investigation of the matter. And so they have taken their own interpretation of that. So how that's resulted currently, there's a case, Suprema versus ITC, where the Federal Circuit decided whether the ITC could ban the importation of articles that don't technically infringe as imported, but would later infringe post-importation. So kind of on the manufacturing versus the consolidation of those pieces. The Federal Circuit concluded that the statutory language was ambiguous, relied specifically on Chevron, and allowed the ITC's interpretation to take hold. However, now that Chevron has been overturned, there are multiple cases that have used that sort of reasoning that are being petitioned for rehearings. So specifically, Google has petitioned for a rehearing in the case of Sonos versus ITC. Sonos specifically is a speaker manufacturing company, and they were allegedly infringing on Sonos's patents for importing speakers that also resulted in some sort of app communication. And so they weren't imported together, and the ITC, given its previous rulings, found infringement. So Google is trying to overturn that now. It's still going as of yet. There has not been any rehearing granted. It's very recent, but we'll have to see where it goes.
So it seems like if Google's starting to seek a rehearing, I'm guessing that probably a lot of other companies are going to do the same thing, wouldn't you think?
Yeah, definitely. It sounds like Google was on the heels of it. They kind of probably expected this and wanted to be one of the first ones to try to get in there. Again, one of the issues with Chevron being overturned is that it will result in a large increase in litigation. And this is just the start. So yeah, companies are probably getting ahead of it there, but it's definitely not the end of it. And likely there will have to be some sort of change to cases that were decided by Chevron now that it's been overturned.
Well, that was a lot of information, and thank you very much. It is much appreciated.
Of course. Thank you very much for having me.
So that's all there is for today's episode of Unraveling Intellectual Property with Michael Stein. Hopefully you'll tune in next time and we can share more thoughts of the impact of various factors on various aspects of intellectual property.